about renewing your membership and our annual dinner, which is on January 16th again at Bayards. We'll send out another, reminder of that next week. Some of our dues, the amount of dues has gone up because we have administrative course that we need to cover. Just to let anybody know if that's a hardship for anybody, you can just email me or Blair Fensterstock and we'll deal with that. So I'm going to introduce Rita Warner, who is going to introduce the musical group.
Good evening. I'm Rita Warner, co-chair of the musical team with Bruce Turkle. And tonight we welcome you to tonight's performance of a Civility Seder. First, I want to join Julia in thanking Sullivan and Cromwell for their incredibly gracious and generous hospitality, for all the audio, video, electronics they provided, and equipment they made available, and of course the delicious food and drink that is here and will be throughout the evening and post-performance as well. Now, the mission of the Inn Court is to foster excellence in professionalism, ethics, and legal skills. And our program tonight has the additional goal of entertainment. If we succeed, we'll all leave with useful information and smiles on your faces. Perhaps you'll even be humming some of the songs we've adapted for this program. You'll recognize the music: Cole Porter, Billy Joel, Frank Lesser, Robert Hammerstein, Alan Menken, played by our Inner Court maestro, Peter Dizozza. But the lyrics are new, written almost entirely by Bruce Turkle, the Inn's master musical wordsmith, humorist, and playwright. Tonight's program is about civility in the legal profession, a topic of continued importance as decorum is more and more a casualty on the battleground of litigation. Can we be polite at the same time we're persuasive? Can we be victorious without being vindictive? Can we impress our clients without being insulting to our adversaries? And is the high road the right road and the most effective? To answer these questions, we've taken the traditional Passover Seder and made it unrecognizable. Well, not quite. We have moved it to the Hanukkah Christmas holiday period. But the purpose remains the same: an occasion to explore and recount the exodus from bondage. In our case, the bondage of bad manners and bad behavior, as you'll hear tonight, in words and song, and with more than a touch of humor. This is the New York Inn's 7th annual musical program, and every year I'm amazed and dazzled by the level of musical talent among our colleagues on the bench and on the bar. And I'm particularly delighted that we have Judge Barbara Kapnick and Judge Richard Sullivan performing as well. And now, for your listening and learning pleasure, we present a Civility Seder, an examination of appropriate behavior in the profession, as we set up our Seder table and light the candles, and then on with the show.
Where rude behavior is established. begin the recitation of the ancient fable of the lawyer's redemption from the bondage of incivility. This program recalls the dramatic and miraculous events which led to the exodus from the land of scorched earth, where rude, acerbic barbs ruled the day.
The American lawyer, centuries ago, instructed us to meet as we do here tonight, when it declared, "And thou shalt tell thy masters and barristers and their guests in the day, saying, it is because of those gratuitous taunts that judges nationwide have declared that we leave the kingdom of incivility." By this, the scribes tell us that young and old should gather on the 12th day of the 12th month, 2012, in order that we might reiterate to younger members and to all this thrilling chapter in the nation of Laurel.
We recall tonight that there were once lawyers who forgot the meaning of civility. We remember those discourteous, disrespectful oaths with the words of the prophets that were written on the subway walls and in the halls of scorched earth.
I don't care when your husband's open heart surgery is scheduled. No extensions. This is the first time my motion is on, and I've mentally marked it as final.
Courtesy is granting extensions, diffusing tensions, showing respect.
Courtesy is cooperating, no witness baiting or wringing their necks.
Courtesy is biting your tongue though you've been abused. And courtesy means ending bitter feuds.
Courtesy is watching your temper, do not dismember adversaries. Courtesy is fewer disruptions, curbing corruption, act decently.
Courtesy is being avenged with more frequency. And courtesy means displaying dignity.
Courtesy is always behaving instead of raving mad.
And courtesy is in your heart and in your soul as well, if you just behave.
Your Honor, the arguments raised by my nitwitted, idiotic adversary are moronic, cockamy, and generally foolhardy.
Courtesy is acting with reason, with no deceiving, getting along.
Courtesy is working together when day is through, and courtesy is those who work with you. Courtesy is
Always behaving instead of raving mad. And courtesy is in your heart and in your soul as well, if you just behave.
We have before us the civility plate. On it, we have placed the main symbols of this presentation.
First, we have the matzah, the dry unleavened bread, which remind us of the blandness of a presentation based on the language of the Code of Professional Responsibility. The matzah are placed together to indicate the unity with which most attendees will exit if the pace of this program does not speed up.
Second, we have the roasted shank bone, which reminds us of the circumstances that ensue when lawyers fail to act with dignity, decency, and grace. A lawyer's shank bone will be roasted If, for example, he withholds consent to extensions on arbitrary or unreasonable grounds, or places unwarranted or irrelevant conditions when granting an extension of time.
The third symbol of the Moree, the bitter, bitter herbs, which reminds us of the bitterness between adversaries who habitually engage in rage, disruption, and abusive conduct.
4 times in the course of this presentation, we shall partake of the wine, symbol of the painlessness of this program after the 4 glasses of wine. As we partake of them, may we remember the obnoxious behavior in which some of our peers have engaged, and may we strive to act more civilly to our partners, our colleagues, the judiciary, and to our adversaries.
We recall on this night that for centuries, lawyering has been regarded as a great and noble profession.
Justice Robert H. Jackson noted the countless examples of courageous lawyers who promoted and supported causes and aspirations of people who were subjected to governmental abuse of power and whose rights would not have been vindicated without the aid of dedicated lawyers.
Consider the role of lawyers in the drafting of great charters of human liberty. Of the 56 signers of the Declaration of Independence, 33 were lawyers.
Of the 55 members of the Constitutional Convention, 34 were lawyers.
In pursuing great causes, the role of lawyers has been crucial, for it was their successful pleading that removed so many barriers to human freedom.
This in turn gave a wider and fuller meaning to the ideals of human dignity examined in the Constitution.
Notwithstanding such overwhelming historical data, we recall tonight that lawyers are condemned to dwell in the land of scorched earth, and the low esteem in which the legal profession in general, and some lawyers in particular, continue to be held.
I have here the Code of Professional Responsibility. Let me tell you some of the salient parts. A lawyer behaving rudely, difficult to endure, due to his loud ad hominem attacks. He only brings on emotion when his opponent is away. He does what he can to hinder and delay. Simple terms, he's ignoring good manners, finding a way to coerce. This lawyer, he believes in scorched earth. Don't they know that the rules of conduct have to be obeyed? Can't they see that the crude behavior is just not okay? Though they act like ill-mannered ogres, they will still get paid. These lawyers, they believe in scorched earth. Lawyers are misbehaving, frivolous claims they bring, causing our name to lose much of its worth. Clients demand their lawyers refuse all polite requests, bloating their productions filled with dreck. Though we object to the tactics employed that annoy and coerce and worse, these lawyers, they believe in scorched earth. You can tell them all day that they need to behave and be courteous, but nothing we say is changing their ways, they're just hurting us. Cause the code to which they're adhering tells them, do your worst. These lawyers, they believe in scorched earth. And furthermore, all the yelling and screaming is music to cool lawyers' ears. Decorum will destroy their careers. When they deal with an adversary who plays things fair,
Berenson, speaking as an attorney, once said, "Our duty is a much larger thing than the mere advice of private clients," adding, "We are servants of society, officers of the court of justice."
On this night, we recall that attorneys, as officers of the court, have a duty of complete candor and loyalty to the court and have been sanctioned for abusing the discovery process.
Sanctions have been imposed for maintaining frivolous appeals in violation of attorneys' duty to promote the administration of justice.
Gross displays of lack of cordiality and fair play hardly surprise, since even simple requests are often met with a lack of basic consideration.
We now must ask the basic questions of civility. What is civility? What are the obligations of civility? How is civility distinct from other professional obligations of lawyers, such as ethics and professionalism?
Civility, saith the elders, refers to the ideals of professionalism, such as respect, courtesy, and decorum. One court noted that it is more than surface politeness. Rather, it is an approach that seeks to diminish rancor, to reconcile, to be open to non-litigious resolution.
The common concepts of civility recognize the importance of seeking agreement and accommodation with regard to scheduling and extensions.
Be respectful and act in a courteous, cordial, and civil manner.
Be punctual, prepared, and keep commitments.
Maintain honesty and personal integrity.
Communicate with opposing counsel.
Avoid actions taken merely to delay or harass.
Ensure proper conduct before the court.
Act with dignity and cooperation in trial proceedings.
Act as a role model and mentor to younger lawyers.
They served me Friday evening. One foot was out the door. I swore, then sought a brief extension. What could be their objection? I said I need a few days. No TRO was sought. I thought I'd get it without question, without court intervention. But to my dismay, request rejected. No extension, not a single day. No reason given for their curt rejection. Just an email stating we refuse. A few days, that's all I asked of you. No courtesy extended, no decency displayed. Oy vey, all I was seeking was not to work the weekend. The matter was not urgent, no emergency there be. You see, I need just a few days. How about a week from Tuesday? No one listened, just complete resistance. My insistence could not win the day. The more I pleaded, the less they're conceding, treating me with rancor and abuse. A few days, that's all I asked of you.
Reckless disregard of these rules caused lawyers many generations ago to be exiled to scorched earth.
How did this tribe find themselves dwelling in this land?
Through deception, nastiness, attempts at intimidation, and a general lack of civility.
For it is written that there were those who treated litigation like war and who described trial practice in military terms.
And who believed that it was invariably in their interest to make life miserable for their adversaries.
and who had a wondrous facility for manipulating facts and engaging in revisionist history.
Those who enjoyed making unnecessary motions and using discovery primarily to oppress and burden.
Some blame the law schools who have taught the adversary system as the focus of the study of law.
These introductory lessons, reminiscent of primitive trial by battle, have a more important moral effect on law students.
Students are conditioned to look for any debatable issue that might yield a dispute or a zealous argument. They're not trained to search for an equitable solution to legal problems or a common ground between contending parties.
Concentration on the adversary system accentuates the differences that might have been resolved by negotiation, placing the focus on bitter and prolonged litigation.
Some prophets blame the law firms for fostering incivility. They believe that law firms create a culture in which retaining work and collecting fees resulted in a narrow focus on winning at all costs, which comes at the expense of civility.
Canons of ethics and professional responsibility have always set forth the outer boundaries, for it is written that a lawyer should represent a client zealously within the bounds of the law. However, lawyers too often venture outside the bounds of decency.
I'm a fool you do not want to oppose. I'm boorish and bothersome, and I always say no. No matter the issue you raise, I will not grant you even one extra day, or allow you to have your say. When I speak, I just rant and rave. I never behave. Get no respect from my peers. I ruin careers, drive young colleagues to tears. I am insincere and can be your worst fear. I'll give you a kick in the rear. Your name I'm aiming to smear. Neath this veneer, I'm a jerk. It is clear, judges jeer when I'm drawing too near. I'll give you a kick in the rear. Give you a kick every time I see you're just about to argue. I'll tell the judge it was only a nudge. How much of a wuss really are you? I love to kick it in
dwellers in the land of scorched earth was the Texas criminal defense attorney, who was held in contempt for making a gesture simulating masturbation towards a prosecutor while appearing before female judges in the courtroom. The lawyer was held in criminal contempt and sentenced to 90 days in jail, which was upheld because his obscene gesture was a purposeful act of disrespect and affront to the dignity of the court.
There was also the Minnesota lawyer who was suspended from practice following a series of ethical complaints about his unacceptable conduct in and out of court towards lawyers, bystanders, and witnesses. The attorney accused the judge of colluding with the prosecution, of racism, of conducting a kangaroo court, of conducting a cockamamie charade of witnesses, and of being caught up in his own little dream world. The lawyer also repeatedly hurled disrespectful remarks towards his female opposing counsel. The court expressly discounted the lawyer's claim that his conduct was the result of zealously protecting his client's cause and the emotional undercurrent of the litigation.
A young lawyer resided in scorched earth for having vented his frustration in responding to plaintiff's deposition scheduling requests by writing "stupid bitch" 4 times on his correspondence file copy, later inadvertently filing the copy with the court as an exhibit to a discovery motion and serving the motion on 26 other counsel. The Minnesota Office of Lawyers' Professional Responsibility concluded that while intent to publicize was lacking, the offensive gender-based comments were inappropriate and could have embarrassed or burdened people within the lawyer's firm, even without circulation.
And so it is with regret that we recall these tribesmen who placed the trial attorney on center stage rather than the client or his cause.
And how does one recognize those with this win-at-any-cost mentality?
They foam at the mouth during depositions.
They had framed pictures of the family piranha in their office.
They were voted most likely to harass, delay, and obfuscate in high school.
They continually seek clarification of difficult terms like you and when.
And how do you know when these practitioners are lying?
Their lips are moving.
The sages ask whether lawyer incivility is of recent origin. Some argue that, in fact, there was no golden age of civility, but instead only a time when the legal community was small, closed, and discriminatory. According to this argument, civility was maintained within a closed society, barring entry to those who would bring diverse viewpoints to the bar.
Some scholars argue that incivility derives from ignorance on the part of the lawyer and client who do not understand that civility is expected and ultimately is the most effective approach to advocacy.
Others argue that lawyers, being the product of an individualistic and uncivil society, will be uncivil themselves.
Dean Roscoe Pound described the adversary system as the common law doctrine of contentious procedure, which turns litigation into a game.
We pause now for a brief word from our sponsor.
Do you suffer from Rambo litigationitis? Do you oppose extensions of time merely because an adversary opposed you?
Have you handed your opponent a reply brief as you walked into the courtroom for an oral argument? Do you roll your eyes or shake your head during your opponent's argument? Have you argued that opposing counsel is lying when the brief merely contains a simple typographical error?
If any of these symptoms sound familiar, you may need decorum. Yes, decorum. The small pink tablet guaranteed to remedy sharp tactics, decrease childish tantrums, and eliminate downright trickery. Just listen to these testimonials.
I couldn't believe how fast decorum worked. One pill and my snarly sarcasm was gone, and more of my objections were being sustained. Thanks, decorum.
I never thought decorum would work for me, but after just 2 doses, I never referenced matters outside the record again.
Decorum, the fast-acting, good-tasting, I can't believe I am no longer raising frivolous arguments method. Take only as directed.
Now, back to the Seder.
The sporting theory of justice, as Pound called it, not only irritates parties, witnesses, and jurors in particular cases, but also gives the whole community a false notion of the purpose and end of the law.
Commentators, speaking in vernacular, have called this the hired gun approach. That is, the party who engages in the most unprincipled, willing to say anything to win strategy is the one most likely to prevail.
One commentator noted that lawyers are hired guns. They know they are, their clients demand them to be, and the public sees them that way.
We now recite the 8 plagues causing incivility in the profession.
The growth of the bar, which leads to increased competition and more animosity.
The adversarial legal system, which pits lawyers against one another, leading to combativeness.
Poorly prepared law graduates.
Clients who want combative lawyers.
An erroneous view that civility shows weakness.
Pressures to increase billable hours.
The shifting of many litigation proceedings to out-of-court depositions where lawyers may feel freer to appear belligerent in an effort to impress clients.
Individual lawyers' poor moral conduct.
Someday
matter of in re SC, which stands out as brazen even among civility cases. In addition to disparaging the trial judge, California attorney Julie Lynn Wolfe used offensive language to describe her client's developmentally disabled minor daughter. In trying to discredit her testimony, Wolfe said the girl was, quote, akin to broccoli and pretty much a tree trunk. His testimony was jibber-jabber.
The court found Wolfe's characterizations shameful editorializing that were gratuitous and offensive. The court condemned Wolfe's conduct, noting with dismay the ever-growing number of cases in which most of the trappings of civility are lacking. Because of Wolfe's contemptuous attack on the girl and her numerous other transgressions, the court referred the case to the state bar, and Wolfe was shockingly disbarred.
An Ohio lawyer, Mark Foster, in correspondence asked whether the family of the opposing party had been seriously inbred, described the litigant as an anencephalic cretin on the lunatic fringe with a single operating brain cell, who made brain-dead ravings and anal rantings. The court initially suspended Foster for 6 months and ordered him to pay costs, but stayed the sanction provided Foster did not commit other violations during the term.
Louisiana lawyer Nicholas Esteverne filed a brief replete with allegations against opposing counsel of professional misconduct, unethical and illegal behavior, which the Louisiana Court of Appeals found, quote, insulting and offensive because there was no supporting evidence.
The court stressed that a lawyer always should act with personal courtesy and professional integrity, emphasizing that our legal system is designed to resolve human and societal problems in a civilized, rational, and efficient manner. Uncivil conduct, by contrast, wastes limited judicial resources, increases transactional costs, delays justice, and causes loss of public confidence in the judicial system. The court reprimanded Esteverne and directed him not to make any further unsupported accusations of ethical misconduct.
Of 4 lawyers, the Bar Association did speak, describing thereby 4 rules of professional conduct.
The wise lawyer knows that incivility harms clients. He is deemed wise because he recognizes that by abandoning civility, he is likely to lose the trust of his clients and of the court.
Sound arguments, not vituperative sniping, persuade courts, states the wise son. Judge Hillel of Parsippany once stated that lawyers need to understand how truly annoying sniping can be. The judge was known to stop reading briefs and instead of aping the court, served as an outlet for pent-up hostility.
The foolish lawyer does not admit or understand that incivility harms the legal profession. He turns a deaf ear to the decreased respect for lawyers and the legal profession.
The selfish lawyer states that you believe that incivility harms lawyers. He is known as selfish because he does not include himself among those who must act with dignity and respect. But the words are sound, since incivility contributes to lawyer dissatisfaction and is also harmful to their health.
The learned lawyer states that incivility can rise to the level of unethical conduct that warrants bar discipline. Applicable rules include Model Rules of Professional Conduct, Rule 4.4, which prohibits behavior undertaken for, quote, no substantial purpose other than to embarrass, delay, or burden a third person, close quote. And there's also Rule 8.4D, which prohibits misconduct that is prejudicial to the administration of justice. Thus, lawyers have been subject to bar discipline due to uncivil conduct, usually in connection with other violations.
They've earned JD degrees, but lack sheer decency, have no integrity or simple courtesy. They bicker day and night, a riot they incite, igniting endless fights, lacking civility. They're condescending, nasty, and smug. Rules always bend. the back, dissing you with their smack. They are such awful hacks, how they abuse us, cursing and worse, disingenuous tactics, scorched earth.
Disbarment by 2 federal courts was the consequence for Antonio Cordova Gonzalez, who engaged in inappropriate financial transactions with clients, but also used flagrantly uncivil language. His vituperative statements and vitriolic slurs were so offensive that the court declined to repeat them, but it said that the pleadings included pervasive, abusive, and disrespectful language against opposing counsel and judges. The First Circuit affirmed the district court's disbarment and disbarred Cordova Gonzalez from practicing before the First Circuit.
Elsewhere, the Kansas Supreme Court suspended Dorothy Gershner in part because she wrote a letter to her own lawyer containing vile and unprintable epithets. The court said the letter reflected poorly on Gershner's fitness to practice law because a lawyer should be able to communicate an argument without using profane language and because lack of civility reflects poorly on the law. The lawyer was suspended indefinitely from the practice of law.
Another court declined to repeat a lawyer's steady stream of uncivil, disrespectful, and unprofessional ad hominem attacks on parties, opposing counsel, and the court. The court found improper the lawyer's purpose to hurl insults at opposing parties and to impugn the integrity of the court. It imposed Rule 11 sanctions and referred the matter to Pennsylvania State Bar disciplinary boards, leading to the lawyer's suspension for 5 years.
The sages warn that too much time on these summaries of incivility will leave those assembled feeling restless and hungry. Manischewitz, the prophet, decreed that practical advice should be given on how to address this situation at a Seder presentation.
Forget what it's costing, just begin defrosting. In-laws about to arrive, so you gotta make a brisket or it's Seder suicide. You can try something sultry, baste a little poultry, serve up your fine-feathered friends. You can make some mindful stuffing when you're roasting Cornish hen. You can fry matzo brie till it's crisp and dry. You'll earn yourself a ham, but your plan, it demands that you please your clan. So you serve a rack of lamb. Your family will feast here, and if even Easter, just make sure you serve it au juice. You gotta feed a lammy, or your clan will fly the roost. You can bake honey cake till the bellies ache, and macaroons are fine, but your brood's in the mood for a special food with their strictly kosher wine. So bake yourself a cake on at the shorter Avon, serve with just a little undime. Make yourself some poultry and your meal will be sublime. You can make sirloin steak or some broiled fish. Your folks will still resist. They'll insist on a dish that is so delish. It's the brisket that they wish.
now turn to the ritual of the Z's, which, contrary to some belief, does not refer to dozing off during our presentation. Rather, these are the words which have been repeatedly blamed for promoting incivility in the profession: zeal, zealous, and zealotry.
Lawyers sometimes defend their incivility by invoking a need to represent their clients zealously, apparently unaware that most states have eliminated the zealous advocacy requirement from their ethical rules.
While former ethical rules did contain a requirement of zealous representation, that requirement was not incorporated into the Model Rules of Professional Conduct adopted by the ABA in 1983. Instead, the Model Rules require reasonable diligence. Moreover, lawyers have never had a special dispensation to aid a client's cause through unethical or unlawful means.
Thus, one court stated that zealous advocacy cannot be translated to mean win at all costs, and although the line may be difficult to establish, standards of good taste and professionalism must be maintained.
Another court emphasized that zealous representation does not mean lawyers are free to be loose cannons.
Several courts have admonished overzealous lawyers, but that has not always deterred comparable conduct by their peers.
A survey of Illinois lawyers revealed 62% chose to ignore rather than confront unprofessional behavior.
Despite the regular presence of mean-spirited and abusive tactics, lawyers have typically refrained from filing formal complaints, thereby allowing the nastiness to continue unabated. Don't talk to me of fair play. I hinder and deceive. Seek an improper stay. Engage in trickery. Misbehave. Whenever my brief is due, extensions I will seek. Creating some lame excuse to gain 6 extra weeks. Misbehave. No matter how much notice of a conference I receive, the first time on a bid is gone, adjourning endlessly. No matter the dates you set, I am certain to preempt your planning. I will upset till threatened with contempt. Misbehave. I will serve you late, so you can't serve a reply. The facts I will misstate and will generally lie. The facts I will misstate and will generally lie. Most documents I'll withhold despite their relevance, leaving you in the cold without firm evidence. Misbehave. The return date of your motion means nothing much to me. Illness I've been actually engaged, resist tirelessly. Responses I will keep short to all your inquiries, making you run to court for trivialities. Misbehave. I won't appear in court when the calendar is called. Long delays I'll cause and will constantly stonewall. Long delays I'll cause and will constantly stonewall.
The commentators speak of lawyers who contend that their critical attacks on the courts are protected by their right to free speech.
The free speech defense is often unsuccessful because the U.S. Supreme Court has held that lawyers' speech in pending cases may be restricted beyond that of regular citizens.
Because states grant lawyers licenses and lawyers are officers of the court, they may be required to, quote, conduct themselves in a manner compatible with the role of courts in the administration of justice.
Under New York Times versus Sullivan, speech made with knowledge of its falsity or reckless disregard of its truth is not protected in any event. Some courts have held that the New York Times subjective standard does not go far enough in protecting lawyers' intemperate criticism of courts. These courts apply a stricter and objective standard.
The objective standard judges what a reasonable attorney, considered in the light of all his professional functions, would do in the same or similar circumstances.
The Ninth Circuit reversed sanctions against a lawyer who had called a judge a, quote, buffoon and substandard human on the ground that most of his statements were opinions, apparently applying a more lenient subjective standard.
Another court declined to sanction a lawyer who wrote that a judge was a racist and a bigot on the ground that his statement was an unsanctionable opinion under the subjective standard.
But yet a majority of the jurisdictions, though, have applied, thankfully or not perhaps, the objective standard.
If lawyers were more civil, they would treat their brethren with respect, wouldn't always yell, object, oi! They'd curb their rude behavior, would not want their adversaries hung, they'd speak with a kinder, gentler tongue. They would not snipe all day for no special reason, or howl every time they're overruled, or scheme to make sure settlement talks always broke down. They would not slant the facts, make false accusations, only truthful stories would be told. When calendars were called, they'd be around. If lawyers were more civil, I'd enjoy their camaraderie instead of making enemies. They wouldn't make me work hard. Briefs would all be drafted artfully, not criticizing, minimizing me. I could devote my time to important decisions, focus on interpreting the law. No more referee backbiting fights. I've had more than my fill of attacks and derision, watching as civility's ignored. Sanction motions brought just out of spite. The least important things they nowadays will bring to me. They are constantly fighting and always posturing. Pardon me, your judgeship, if you please, your judgeship, raising points that nearly make me cry. Beat-a-dum, oh, make them stop. It's Fenster stop. And it don't make one bit of difference if I answer them or not. They don't even listen when I talk. If lawyers were more civil, no more sanctions would I need impose, no more of their purple prose. I wouldn't have to scold them. I was elevated to the bench, where tough justice often I dispense. Why can't lawyers show some common sense? If they did, I'd be a man.
Do not lay blame at the foot of the judges, say the commentators, for it is stated that uncivil behavior typically takes place behind the scenes rather than in venues where it might be witnessed or documented. Moreover, case law limits the exercise of the court's discretion, reserving Rule 11 sanctions for only the most egregious instances of bad behavior.
Rule 11 allows courts to punish attorneys who seek to harass, cause unnecessary delay, or needlessly increase the cost of litigation. However, most courts have held that Rule 11 sanctions should only be applied with the utmost care and caution. Otherwise, Rule 11 controversies would divert attention from the merits of the underlying action.
A panel of wise men from the Second of Circuits highlighted the difficulty of drawing a bright line between actionable behavior and zealous representation. It held that while a court should discipline those who harass their opponents and waste judicial resources by abusing legal process, it is also true that in our adversarial system, we expect a litigant and his or her attorney to pursue a claim zealously within the bounds of the law and ethical rules.
For these reasons, many judges abstain from censuring unprofessional tactics, leaving discipline to other forums. However, courts will sanction attorneys under appropriate circumstances.
Disbarment was imposed on Massachusetts attorney Matthew Cobb for multiple infractions. An appellate judge found Cobb's petition for interlocutory review scandalous and impertinent, and accusing him of bias, unethical conduct, and inappropriate susceptibility to unspecified illegitimate influence. Cobb's quick and ready disparagement of judges, his disdain for fellow attorneys, and his lack of concern for and betrayal of his clients led the Massachusetts Supreme Court to find him utterly unfit to practice law.
A Kentucky lawyer, Lewis Waller, was jailed for contempt and suspended 30 days for uncivil conduct in filing a memorandum of law that called the judge a lying, incompetent a-hole. He sarcastically suggested that an appropriate sanction against him would be flogging, caning, or some other physical torture.
The Kentucky Supreme Court determined that Waller's repeated scandalous language and his lack of repentance required a more severe punishment. He was suspended from practice for 6 months, ordered him to pay costs, and suggested he consider professional counseling.
There's no place in the world for the angry lawyer with his sharp arguments and not backing down. He refuses to give, he refuses to crawl, and he's always at home with his back to the wall. And he's proud of his scars and the battles he's lost, and struggles and pleads as he hangs on his cause. And he likes to be known as the angry lawyer. Give a moment or two to the angry lawyer with his foot in his mouth and his heart in his hand. He's been stabbed in the back, he's been misunderstood. It's a comfort to know his intentions are good. And he sits in his room with a lock on the door, with his books and his cases laid out on the floor. And he likes to be known as the angry lawyer. I believe I've passed the age of consciousness and righteous rage. I found that just surviving was a noble fight. I once believed in causes too. I had my pointless point of view, but life went on no matter who was wrong or right.
And there should be no place for the angry lawyer with his fist in the air and his head in the sand. And he's never been able to learn from mistakes, and he can't understand why his heart always breaks. Even his honor's not pure, nor his courage as well. He's unfair and untrue and will end up in hell. And he'll go to the grave as the angry lawyer.
Yes, there's always a place for the simple lawyer with reasonableness and professionalism. He's most flexible and always willing to listen. And he's always at home at the Bar Association. And he's proud of settlements and the friends that he's made. And he's courteous to all, especially the court. And he likes to be known as a civil lawyer.
Scarsdale of Great Neck, how painful it is to speak of the present decline of professionalism in law, because the legal profession is historically honorable and noble.
The term profession connotes a declaration such as a profession of faith, and idealistic students pursue the study of law because they regard it as a vocation.
The very word vocation holds special significance because it stems from vocare, which means to call. This is the basis for British colleagues who proudly assert that they are called to the bar.
Over the last 30 years or more, overhead costs for law firms have skyrocketed. These costs reflect the increases in associate salaries and escalating costs of training, office space, equipment, libraries, and computers. As a result, profit margins have become a priority while the mentoring and personalized training of new lawyers and associates has almost vanished.
Counselor, thou art so courteous.
I am not so courteous. It has been years since I have shown anyone a courtesy.
But you used to be so courteous.
I was trained as an honest and trusted attorney who treated opponents quite courteously. I hated dissension and granted extensions and hoped they'd be granted to me. I continued in practice and found that the fact is that most of my foes are unworthy of trust, that they would often short-serve me and try to unnerve me, this miserable, uncivil bunch. If you feel that you see me not quite at my courteous best, it's because my opponent is someone I truly detest. For a lawyer who's truthful and tries to be fair would soon end up out on the wrong derriere. Her cause will defame her, no clients will pay her. It's a dog-eating jungle out there. Acting graciously, what good is grace to me? Foes who debase me and act tastelessly. Why should I be gracious when their claims are baseless, behaving contemptuously? If you feel that you see me not quite as my courteous best, it's because my opponent is someone I truly detest.
One day, shepherds appeared in the land of scorched earth. The shepherds offered to lead the uncivil lawyers through the process of sight checking.
The attorneys denounced the shepherds, claiming to be unconcerned whether the cases they cited had been criticized or even overruled, since they too were critical of the profession as a while.
The shepherds realized that attorneys were in need of services much greater than knowing whether their cases were still good law.
As the shepherds wandered through the valley of scorched earth, they did not fear, because as they traveled, they imparted the commandments of civil behavior to the lawyers.
Thou shalt not serve papers in a manner designated to take advantage of an opponent's known absence from the office.
Thou shalt not serve papers at a time or in a manner designed to inconvenience an attorney.
Thou shalt not seek unnecessary discovery or discovery designed to place an undue burden or expense on a party.
Thou shalt not ascribe a position to another counsel that counsel has not taken, or create an unjustified inference based on counsel's statements or conduct.
Thou shalt not respond to discovery requests unreasonably or strain to interpret the request so as to avoid disclosure of relevant and non-privileged information.
Thou shalt not falsely hold out the possibility of a settlement as a means for adjourning discovery or delaying trial.
Thou shalt not obstruct questioning during a deposition or object to deposition questions unless unnecessary.
Thou shalt not act in an uncivil manner regardless of the ill feelings you or your clients have towards others.
As the shepherds led the lawyers through the dark valleys of professional discourtesy, the lawyers started to see the light that led to the land of civility.
Loudmouth bullies now vow to use their indoor voices.
Some even agreed to promote good faith negotiations.
Others promise not to make unseemly gestures towards their adversaries.
One by one, the residents of Scorched Earth committed aloud to refrain from engaging in abusive conduct. And the shepherds declared that a miracle had occurred and rejoiced with a meal of thanksgiving that would preserve professional integrity by eschewing belligerence in favor of patient fairness. And the word of the miracle spread, for the shepherds cried,
One day some lawyers made good decisions, displaying vision of what we could be. Showed us a place where decorum resided. They were now guided by civility. Suddenly civil, good deeds displayed, grow tired of playing their in-mannered games. The suddenly civil, the law is the savior, decent behavior. They've now found the
Lawyers who once would yell and harass you, now always ask you, may I proceed? Lawyers who once would scream and demean you, now always seem to act courteously.
They're suddenly civil. The court is adhered to, except for the with you who still misbehave. They're suddenly civil. They won't interrupt you or try to corrupt you. They've now found their
No more insulting, intimidation, emancipation from nasty displays, extensions given without hesitation, complete termination of dastardly ways.
They're suddenly civil.
Suddenly civil,
It's purifying.
it's purifying.
They're suddenly civil. But what we can be, we learn to be
Learn to be
good.
good.
We're so satisfying. We show understanding.
Show understanding.
Show understanding.
We show understanding. It's civility.
in the following manner, offering practical advice on how to behave in a more civil manner.
What do you do when opposing counsel screams and insults you in every telephone conversation? Hang up the phone, but first declare that unless he or she agrees to be civil, all further communication must be in writing.
What do you do when opposing counsel constantly interrupts depositions with ill-founded objections, and when you object, insults you with, "If you can't take it, you shouldn't be practicing law"? You take a break and allow cooler heads to prevail. If they don't, create a record describing the reasons why the conduct is improper, and that you will be seeking a ruling. Inform the other side that you will be seeking sanctions. If the deposition takes place out of town, call the judge or magistrate and ask the court to intervene on your behalf.
What do you do if opposing counsel has a habit of screaming at you while not saying anything inappropriate, such that subsequent review of the transcript would not reveal the nature and severity of the harassment? You explain on the record what the opposing attorney is doing, perhaps first going off the record and informing opposing counsel that he or she has one more opportunity to shape up before you make a record for the court's review.
What do you do if opposing counsel swears at you, makes inappropriate and insulting gestures, and/or is similarly abusive to your witnesses or clients? You terminate the deposition and require videotaping thereafter, which will have an interim effect and will provide a visual record on which the court can rule. What you must not do is respond in kind, as difficult as that may seem at times. If you resort to the same type of conduct, you become the same as the other uncivil lawyer, will expose yourself to countercharges and even potential discipline.
Above all, prepare yourself mentally in advance for the deposition or meeting or telephone conversation to anticipate, of course, potentially inflammatory language.
Thinking about and anticipating the situation will allow you to control your emotions and your responses so that you do not respond in kind.
Remember that such temperamental behavior is intended to manipulate. If the attorney provokes a hostile reaction, he or she has achieved the goal of engagement.
Opting out of the situation and declining to participate is perhaps the most exasperating response that you can provide.
And by these lessons, the lawyers were able to make exodus from the land of scorched earth.
Amen.
This is exodus that we recall this night to dispel the belief that lawyers are necessarily dishonest and to confirm that they are worthy of trust and confidence.
And so we recite these words to remember the residents of scorched earth who rid themselves of their over-aggression and in so doing became civilized.
In every generation, each lawyer must look upon him or herself as though he or she personally was among those who went forth from the land of scorched earth. Not our retired partners alone were redeemed from incivility, but also we and our associates.
The struggle for civility and integrity is a continuous struggle, for never do lawyers reach a state of unquestionable courtesy and decorum.
In every age, we must renew our commitment to civility and decorum, adding to the advancement of satisfaction with our profession.
Every generation of lawyers are duly bound to contribute to this growth. Else the profession's ideals become stagnant and stationary.
The events in scorched earth were but the beginning of a force in legal history which will forever continue.
In this spirit, we see ourselves as participants in the exodus from scorched earth, but we must dedicate our energies to the cause there began.
In our day, we shall defend the heritage of civility, taught by learned justices and preserved by white shoe firms.
It is through these words that lawyers will continue to inhabit the land of civility.
I am passionately proud of my profession, therefore my word is my bond.
I am responsible to assure that all persons have access to competent representation, regardless of wealth or position in life.
I will be loyal and committed to my client's lawful objectives, but I will not permit that loyalty and commitment to interfere with my duty to provide objective and independent advice.
I will advise my client that civility and courtesy are expected and are not a sign of weakness.
I will treat parties and witnesses with fairness and due consideration.
I will always be conscious of my duty to the judicial system.
I will not engage in any conduct which offends the dignity and decorum of proceedings.
And so it was, and so it is written, that lawyers left the land of scorched earth and entered the land of civility, prepared to treat each other, the court, with respect, diligence, punctuality, and to protect each other against unjust and improper criticism and attack.
Lawyers rude, ill-mannered, heartless pains, who screamed without a cause. They were treated with complete disdain, so they changed their ways forevermore. They were not entering the land of civility, land of civility.
The meeting grew.
Now we have put this behind us, trying hard to be more gracious, so the public will not hate us, and our colleagues won't disgrace us. Civility. Civility. There's no need for vulgar language now.
Get your autograph.